Hi, my name is Amar. Welcome back to Conversations with Jennifer. Jennifer's an estate planning attorney. And today we're going to do another kind of like case study or family study. And this one is more in tune to what we would say is older couple. Would you say that? Jennifer, why don't we dig right
Correct.
into it?
Yeah. So I, obviously meet with all sorts of different clients. The first case study we did was kind of, a couple in their 40s. They have young children and are amassing, their own kind of net worth. Um, that's a very common group of clients. This one that we're talking about today is, the older couple, the couple in their mid to late 70s. They've been married a very, very long time. They have children who are all, older, established. This scenario, I have spouse one who's 76, spouse two who's 73, and the three children of their marriage are ages 50, 47, and 45, all doing well, all financially responsible. The only kind of peculiar issue, or not peculiar, but the only issue is one of their kids, one of their three children, does not have any children. And so typically with those types of spouses, I look at their existing estate planning documents to see what is the administration process when the first of them passes away. And with clients at this age and that length of marriage, and depending on the size of their estate, we oftentimes try to simplify the administration when the first of them passes away. Oftentimes, these clients did these documents 20 years ago.
Yeah.
Just now looking at it. So they put estate planning documents in place when their children were much younger. When the estate tax system was very different. So you had to create that irrevocable trust and you had to have a more complicated administration just based on our tax rules. So if there's a way that I can simplify the administration when the first of them passes away with a family like this, I tend to go that route. And clients of mine appreciate that, because what they don't want is to suddenly have to create various sub-trusts and have a really involved administration, especially where they're at age-wise and the length of marriage. The other thing is looking at how are the assets distributed to their kids. Again, if they did these documents 20 years ago, their kids were younger, maybe not as established yet, maybe not married, no kids. So looking at the situation with the children and seeing again, are the distribution provisions still appropriate? Should we update them? Can we update them? Also, now we have multiple generations who are living. So the ultimate contingent beneficiaries, that provision doesn't become as important or critical, but they do have a child who does not have any children. So for that child, where are his or her assets going to be distributed? Do they care? And kind of walking through the options. Do they want all of their assets to stay down their family line? Do they want to give their children, even the children with children, do you want to give the flexibility to that child to just receive the assets and then it's just a part of their personal estate plan? Or do you want to build in trust provisions so that you have a bit more control? So we work through that, but it's a really different discussion because these kids are well established, and you're not looking to protect them from themselves as much because they're financially sound, they're doing well, they're older. But again, walking through what are the different options, and are you okay with it just being an outright distribution? In which case, one of your kids may be giving it to someone else and not down your family bloodline. And are you okay with that? Sometimes clients say, yeah, we're fine with that. Once we pass away, it's theirs and it's up to them.
Up to them to decide. Yeah.
Yeah.
One thing that you brought up is sometimes fair is not equal or equal is not fair, right? And
Yep.
so a lot of times, even when you have financially well-to-do children,
Yep.
let's say one is a business owner and the other two are professionals, that have a W-2 type income. The
Yep.
business owner may need some loan from the bank of mom and dad,
Yep.
for a couple of months, to make payroll during COVID, and
Yeah.
then they'll pay it back, right?
Yep.
And so, how do you define, especially at this ages where parents are more willing to dole out money while they're living? How do
Mhm.
you equalize that part of the trust?
Yeah, so that's a great question, and you can do it a few different ways, and it really kind of depends on the client. So sometimes, yeah, it is done through a loan. So, like you brought up, the bank of mom and dad,
Yeah.
that's the lender, and so it's really just including provisions in the trust or the estate plan dealing with what's going to happen to that loan when surviving parent dies. You can forgive it. You can off the top, meaning, the child is just going to have that note forgiven, but they're still going to get a 1/3 equal share of the trust. You could also have it where they really just want it to be in thirds, so that note will be allocated to the respective child's 1/3 share. The problem is if the note is bigger than the 1/3 share, then we run into some potential issues. So talking to the clients about how much is this loan, and what do you really want your other two kids to hold a note that their sibling needs to pay them?
Yeah.
That's a very uncomfortable situation potentially. So walking through the different options on that. The other is they could down the road just decide to forgive that note while they're both alive, and that's just a gift. So,
Yeah.
and then again, then it's divided in 1/3, or you do an equalization. But it's really having that kind of detailed conversation with the client about what do you want, on this. Do you want this to be a part of their share, or do you want it to be off the top? And how are your other kids going to feel about it? But it's true. You don't have to treat your kids equally. I mean, we as
Yeah.
parents always feel like we have to, but you don't.
They're
So
individual people.
correct. Correct.
Yeah.
There's always a desire too to list all three kids as co-trustees. And sometimes that works, but other times it is administratively a nightmare. So to have three people agree unanimously and make decisions together is cumbersome and complicated. So that would be another issue that I'd talk to the clients about. Do you want all of them acting together, and what are the potential pitfalls with that?
Yeah. Yeah, I remember I had a client a while back where it's similar scenario where two children had, or they had grandchildren from two children, and one child didn't have any children,
Yep.
and they were funding the 529 plans for the
Yep.
grandchildren, but this child didn't have any children,
Yep.
so instead they asked that child, "Where do you want us to make a charitable gift?" And then
Oh, that's
that's
great.
how they equalized the
Yeah.
estate.
Yeah.
But it's something. I think the key takeaway here is communication, right?
Yep.
Like, especially when we're getting to our mid to late 70s, like communication through the family will
Yep.
keep a lot of peace, and
Yeah.
lot of easier planning needs for to be met by family members. So
Yeah, and making sure it's documented. That's a huge piece of it. What mom and dad necessarily understood is not necessarily what all the kids understood. So putting it in writing also helps with some of that. So
yeah, absolutely. Well, everybody out there, thank you for watching. And if you like this type of content, please hit like and subscribe. It helps other people find Jennifer and I on this worldwide web. And if you have any questions or comments, please leave it below. Thank you. Thank you, Jennifer.
of course, thank you.